Hi, I'm Austin Davis. I'm the Government Affairs Manager for the Lake Champlain Chamber, and I have with me three fantastic employment attorneys from the Lake Champlain region who uh, dedicate some of their time now and then to talk with us about some of the things they're seeing in the field, whether that be now that we're back in legislative session, legislation that's moving, or just things that they're dealing with their clients on a day-to-day basis. So today we're looking to talk about a couple pieces of employment legislation that are under consideration right now in the Vermont legislature, as well as just some of the general COVID strain and impacts that we're seeing on human resources and employment. So I think we'll lead off with Kerin, and we'll talk about H329, which is an interesting piece of legislation that she actually testified on not long ago, as did I for the Lake Champlain Chamber. Why don't you take it away and give us a quick overview of what the bill is and does?
Sure. I would say that it is a bill that I think was intended to change several things about the way that discrimination needs to be proven or how discrimination cases can be brought in the state of Vermont. Ben can speak to this a little bit if he wants, but it sounds like it was inspired by some changes that were made after the Me Too era in New York law. But there are a couple of specific things that I testified about that may be of interest. Number one, it is a bill that hasn't yet, as we are aware, been reviewed by the Judiciary Committee. And just as a matter of practice, anytime you're going to have a significant change in law, it's always my thought that having the Judiciary Committee take a look at it can be helpful. And so I recommended that and hope that the legislature will do that. I think there's the first thing in the bill that came to mind for me that's probably a good thing is a codification of a statute of limitations at all with regard to discrimination cases. We in Vermont have not had, the Vermont Fair Employment Practices Act has not had a statutorily defined statute of limitations in terms of the amount of time that somebody has to bring a claim from the date that the bad thing happens to the time that it's expired. Basically, it's too late for you to bring it. And so we've really been dealing with two interesting types of statute of limitations, depending on the types of damages. So if they are damages that are related to contract, potentially like wages or something like that, we've been dealing with a 6-year statute of limitations under Vermont law. If it's something that's more personal injury related, it's gone with the personal injury type statute, which is about 3 years. So they are suggesting a 6-year statute of limitations here. I'm at least glad that they're codifying one. Whether or not you think 3 or 6 is the right answer, that's up to you. But I think that I was glad that they actually put one in there because I think that can certainly be helpful. There were a couple things about the bill that I just explained to the committee that there were some pieces in there, the way that the language was written seemed to fundamentally change the way that these kinds of cases are proven. There's a test that goes back to the 1960s called the McDonnell-Douglas test, which is really a burden shifting. Anybody that wants to bring discrimination cases has to demonstrate somehow that either directly or indirectly by use of perhaps impacts over time. Somebody needs to show that they were treated differently than somebody else who doesn't hold that same personal characteristic that they think was the basis for discrimination. And so there was some language in this bill that talks about not needing comparators. There was also some language that talked about one of the standards that's used consistent with not only McDonnell Douglas, but some later cases. You don't have to show that somebody actually intended to discriminate against you under current law. You can show that by the circumstances, it looks like that discriminatory intent or that characteristic of you, whether it's your sex, your race, your national origin, was a factor in whatever the decision was that was made. So what they try and do here is actually simplify by saying you don't have to compare yourself to anybody else. And that really it's got to be something that's more than trivial, more than something slight, but that you don't have to show that whatever the bad thing was that happened was severe and they actually said and pervasive, but now the language might be or the real language is or pervasive in the current test. But the language was a little unclear in this bill, and I pointed that out that they may want to take a look at that a little bit to see what they were trying to do with the standard. But the idea is that I think this bill needs a little bit more work, would be my suggestion, just because I think it actually has some unintended consequences with the burden of proof as to who has to prove that it wasn't something that was just slight or trivial. And also, it is going to be a significant change in what that burden of proof looks like, which is going to put Vermont in a unique position, which on the one hand might be a positive thing, on the other hand could also be something that concerns businesses about employing Vermonters. So it was a bill that I made some suggestions as to some things they might want to take a look at, but that as written, I think isn't quite ready for prime time would be my basic thought on it.
Ben, do you want to tell us a little bit about New York's experience with this? And it sounds like some of the language is similar to what's been done in New York.
Sure. Well, it does appear that the language that Kerin just gave a real good overview there for is based off of the law that was changed in New York under the New York State Human Rights Law about 3 years ago or so in 2019, right in the wake of the Me Too movement and Harvey Weinstein. And look, whenever I have a client call me up that's facing a troubling claim of sexual harassment or harassment, my conversation with them usually starts that there's two different standards of what's wrong here, right? There's what's wrong in the eyes of the law, and there's what's wrong in the eyes of common sense and what any of us would consider to be inappropriate workplace conduct. And it's long been understood that wrong in the eyes of the law is a very high bar. The severe and pervasive standard requires that someone be subject to such severe, such pervasive harassment or discriminatory conduct that it really changes the terms and conditions of their employment, and in many cases effectively leaves them no choice other than to leave their job. I think we'd all agree that there's a whole lot of inappropriate conduct in the workplace that falls underneath that bar. So New York made an attempt to lower that bar from the severe and pervasive standard to something lower. I understand why here in Vermont, we're looking at that similarly to align the law more with what we would consider to be inappropriate conduct. I know the bill, I agree, still needs some work. And as you mentioned, Austin, it's still going through the committee process here. So we'll see where it ends up. But I think that was the intent in New York. And I understand that's the intent here in Vermont. You know, what I would just add is where one direction that I do think that this very likely may be heading in is, as Kerin said, increasing the statute of limitations for all claims from 3 years to 6 years. And so what I would say is a good pointer for employers here is all the more reason to make sure you're documenting all the claims that you receive along these lines, that you're doing good investigations, that you're documenting your interviews and all those investigations. Because look, you know, I barely remember what I did 6 days ago, let alone 6 years ago. And so it's important that you have that evidence and those documents on file. Good reminder, right, for record keeping practices. You know, we usually advise employees, look, keep all records for at least 7 years, because at least then you'll be beyond the 6-year statute of limitations. I think this doubles down on that recommendation, is to keep your personnel files for at least 6 years, perhaps 7 years after folks leave your employment.
I think that's generally good advice with everything, is documentation is definitely your friend. Now, one thing that concerned us, and we testified to as well, I think as well as some other folks did, is language in the bill that seemed to kind of deter following internal processes. It wasn't necessarily doing so in an advert way, but it could be construed that way. Kerin or Heather, did you read that language, and would you have any suggestions on how that should go?
Well, I did read that language and had a couple of thoughts about it. One is that the sexual harassment law as it currently stands today already requires employers not only to have a written sexual harassment policy that gets distributed to its employees. For most of them, that means that it's in their employee handbook, but it requires, as part of your sexual harassment policy, that you tell employees the state and federal agencies to which they can report their complaints. So there is already an avenue and a mechanism in the current law for stating that you are not required to simply try to resolve this internally. That sort of part two of my reaction to that provision is that there is well-established case law that employers have relied on for years that make it clear that having a good internal complaint process as a way to respond to complaints of sexual harassment is a defense or an affirmative defense for employers to claims. And so I was concerned about how this language would affect that defense, not only from a legal perspective for employers, but also from the perspective that having those very good internal complaint policies, if done correctly, they really are intended to address these problems quickly and efficiently, much more quickly and efficiently than trying to bring a lawsuit which takes years to resolve. So those were my observations about that particular provision. I don't know if Kerin or Ben had additional observations.
Yeah, I will say one thing. When I actually saw that part of it, I understood the intent of it. And going back to what Ben was saying about, there's a difference between the legal requirement and best practices. Best practices is always going to be higher. And each of the lawyers on this call, we always teach our clients, do better than just the minimum that the law requires. So totally understand that part. But I think, again, I think it was well-intentioned because there's no question that people are concerned about retaliation. It's hard to come forward with a claim. It really is. And, and I think that they wanted to avoid that consequence, but the manner in which the language reads, it almost provides a disincentive for somebody to come forward. And this is what I mentioned to the committee is, already you do not have to report internally. You can go external immediately. You can go to the state, to the Attorney General's office, in an employment situation, or you can go straight to the EEOC. You have options already. But suggesting to somebody, well, if you don't do that, then it's actually going to help you in a lawsuit. I think that's kind of hard because then what you're doing is telling people who are investing time, energy, and money on either 1-800, anonymous opportunities to claim, or who have really good HR departments who can address it. Who, like Ben says, do a good investigation, make sure that they right the wrong. It will prevent people from doing that. And I think that that is not helpful for that relationship between the employer and the employee and may do more harm than is good. I understand the intent. I know that retaliation is real, but that language was something that I thought probably should be changed.
Yeah, these are difficult conversations because I think, everybody wants to see what's done be best for everybody. And, they're just sensitive by nature. These are life-altering situations for a lot of people. And the way in which everyone around it responds can have massive implications. So, I think it's very difficult to legislate these types of things. And, the complicated nature of all of the situations that statute needs to be applicable to and respond to really makes it so that finding a suitable solution that doesn't have unintended consequences is difficult. And I think that's what we're really seeing here. And it remains to be seen how this legislative process pans out, but we hope that, a good final bill can be arrived at that does what's intended without any unintended consequences. And I think, as you said earlier, Kerin, and as I said in testimony as well, stop at the Judiciary Committee will probably be a large part of that. On a similar topic, there's another bill that's under consideration in the same committee, and also I testified on that on behalf of the chamber. This is H320, which kind of tries to build off previous legislation that the state's done, and it's often colloquially referred to as "Do Not Darken My Door." Heather, you want to give a quick overview on that legislation and what your thoughts are?
Sure. Before we jump to that, I'd just like to add one more takeaway with respect to H329 for businesses in particular. As the legislature remains focused on this issue, and as this bill continues to go through committees and be considered, I think we all would agree that it's a good time to remind employers about the importance of sexual harassment training and anti-discrimination training, and how annual education of your supervisors and managers continues to be really, really important, not just to make sure that you're complying with the law, but also to make sure that you have the kind of workplace and culture that you can feel good about having. So I just wanted to give that takeaway before I moved on to H320.
That's certainly a good takeaway. And if folks are looking for that kind of assistance, definitely can, in the links that are accompanying this video, find ways to reach out to everybody on this call who offer those services. Just a quick plug for you all.
So H320, I think of it as, the no rehire kind of provision. It's building off of a Vermont provision about settling sexual harassment cases when those cases are settled, to not include as part of the settlement agreement that the individual, assuming they're parting ways, that the former employee cannot be rehired. Now, there has long been EEOC guidance suggesting that suggesting that no rehire provisions may be a form of retaliation that's prohibited under discrimination statutes. So what I mean by that is that the EEOC has long suggested that including a no rehire kind of provision in a settlement agreement may be a way of retaliating against a former employee because they came forward with claims of harassment or discrimination. Again, that was guidance that did or did not get picked up by various case law. So that sort of also contributes to the foundation behind 320. H320 extends this idea of no rehire provisions in settlement agreements from sexual harassment to really any kind of discrimination claim, and is a absolute prohibition as currently proposed of including in a settlement agreement a provision that the former employee will not and cannot be rehired by the employer or its parent companies or affiliates. The interesting piece about this, in some ways at first glance, this provision might not seem, so problematic in the sense that it's not convoluted or difficult to apply or difficult to understand what is intended. But given the fact that people on both sides of the aisle, and by that I mean attorneys who represent employees and attorneys who represent employers, have spoken out against this provision as really creating unnecessary barriers to settlement agreements. I think that speaks volumes about what are the real problems or potential problems with H320. More specifically, I think people, again, who represent employees as well as those who represent employers, both would admit to and agree about, is that in many, many, many instances, unfortunately, by the time the parties, the employer and the employee, get to the stage of a settlement agreement, the relationship is really broken. It is broken. It is a toxic relationship between the two, and both sides realize that a permanent parting of ways is in both of their interests. For employees, one of the things that attorneys for employees would say is that this legislation may actually deprive them of a bargaining chip in the settlement process. In other words, simply put, they might be able to get more money or more consideration if they are allowed to include a no rehire provision. And employers, attorneys for employers would say that one thing that the employer is really looking for with the settlement agreement is finality. They want to be done with this relationship and everybody to move on and know that there's an endpoint. So again, people who represent sort of both parties' interests, employers and employees, have expressed concerns about H320 for some good reasons.
So it's kind of sounds like the long and short of it is that, love them or hate them, these provisions are mutually beneficial to both parties at the table trying to have a settlement. And it's probably the vast majority of plaintiffs don't necessarily want to find themselves rehired by that employer anyway. So it'd be you have to search very long and hard to find a plaintiff who wouldn't benefit from this provision in the way of increased consideration at the end of the day.
I think that's right, Austin. I think that once again, we would say that for many, plaintiffs, attorneys, and the employees they represent, that having legislation that bars these provisions from being in settlement agreements has the unintended consequence of making them worse off.
Anybody else have any other thoughts on this section or this particular piece of legislation?
I'll just say really briefly, and I think Heather did a great job there of giving an overview, and Austin, I think your wrap up was right on as well. Again, I think there's another piece of legislation that is well intentioned. I think for that, employee who troublingly, has actually been discriminated against or has been harassed, I can understand how saying how that employee cannot come back and work for their prior employer may seem like it's penalizing. But for those folks in particular who have been victims of discrimination, harassment, almost always, as you've said, they don't want to come back and work for their former employer. Where these do not rehire provisions, in my opinion, have been most useful are for those folks who do not have valid claims of discrimination or harassment. And you have employers who, simply to avoid the time and cost associated with litigation, may be willing to, put a relatively small amount of money in some form of severance package just to resolve the matter and move on. You have sort of the litigious employee, right, where there actually is a concern that because this employee brought a claim that may not be valid now, may turn around and apply for re-employment with the same employer after they've settled their last case and simply say again that if they're turned down for employment, it was for the same invalid reasons as before. And so I think particularly in those cases, it can be a useful settlement tool. And I do think that while well-intentioned, it may have some unintended consequences.
It's just an extension too of, and it's like an expansion of the application. This is already part of the law with regard to claims of sexual harassment. So it's extending it basically to all forms of discrimination.
Yeah. So let's wrap up real quick. And before we do that, let's just kind of take a second to talk about, you folks represent many people in the Lake Champlain region and beyond, and see a lot on a day-to-day basis. You're probably the best pulse we could take on how human relations is going in the region. And the COVID pandemic is not over. In many ways, it's just getting harder. I think folks like to say, things are a marathon, not a sprint. I think a lot of folks have treated the pandemic as a sprint, and it's turned into a marathon. And then now it's maybe into an ultra marathon. And so let's start, well, I guess we can start with Ben. What are you seeing out there in the world? What's worrying you? What's some advice you'd give to folks?
Well, look, I mean, personally, I know more people who have COVID right now than at any point during the pandemic. As a parent of young kids myself, I have personally felt the struggles and have seen other parents struggling with kids getting sick or kids having to quarantine or kids' schools being closed as well because of COVID. And what's interesting is we had nationally this FFCRA extra paid leave available for the exact reasons why folks in Vermont are having to take leave now. We had that available early on in the pandemic. It's not around now, but arguably, now is when in Vermont, when we're feeling this sort of most acutely, it's when we need it the most. And so, a lot of employers right now are dealing with significant staffing shortages. Not only do we have sort of the great resignation going on, so to speak, but we also have employers day to day waking up to call-ins and absences because folks themselves have tested positive or they have to stay home with their kids. So there's a lot of intersection here with paid leave laws. Vermont put into effect a Paid Sick Leave Act a few years ago. We weren't thinking of a pandemic at all at that point in time, but here we are, and there's a lot of provisions in that law that allow employees a right to take time off, whether they've tested positive or if they're caring for their child because their school is closed or they tested positive. I've talked to a lot of employers where they're questioning, whereas FFCRA is not available for my employees having to take time off, should I offer them extra leave beyond the PTO, vacation, sick leave that we already give them, or should we require that they use the leave that we already provide? I've seen that put some employees in some really difficult situations because even if they themselves have COVID or if they're feeling symptoms, they're put in a place if they don't have extra leave time available, where they're having to decide between perhaps taking unpaid time or dipping into a leave pool that they were planning on using for vacations later in the year. So, I've seen some unfortunate situations with employees who have symptoms or even have COVID coming into work because of those concerns, and employers having to deal with that. Employers have had to be, I think, really flexible, and employees really, people have had to be really flexible with staffing shortages, having to put in different hours, having to work overtime they haven't worked before. And finally, what I'll say is there's been a lot that's happened here with vaccines as of late since we last spoke. There were a number of federal vaccine mandates put out by OSHA for employers with over 100 employees, for federal contractors, as well as for healthcare institutions. Only one of them has made it through the courts, and that's the provision that's in place for healthcare institutions. But just because the OSHA mandate and the federal contractor mandate have been overturned or are still hung up in courts, that doesn't have any impact on an employer's right to themselves still put a vaccine mandate into place. None of that law has changed. If you go back and watch our previous videos, we've had discussions on the vaccine mandate. And so all of those provisions remain in place. Employers can still put a vaccine mandate into place regardless of those court cases, as long as they leave a path open to those employees who need an exemption, either because of a medical condition or sincerely held religious belief, to request that. So that, from my perspective, is a brief COVID update, but I know there's a lot going on here, and I'd be happy to hear from Heather and Kerin as well as to their own experiences.
Yeah, I'll pick up on the vaccine piece and say too that, I think some of the COVID impacts, the long haul for the law, people basically the long haul COVID for the law, is a lot of it is impacts too on organizations and employers who have collective bargaining units. We're seeing vaccines, for example. We were talking about this before, that, just recently in November of last year, when OSHA was proposing some of those regulations, the National Labor Relations Board's general counsel put out a guidance that basically said, if you're going to have a vaccine mandate, right, even apart from ETS, then you need to be thinking about the fact that that may be not just something that you have to do the impact bargaining on, but in fact, the general counsel for the NLRB said, we think it's decisional. We think it's decisional bargaining because you're fundamentally changing the terms and conditions of employment. So employers are having to deal with that, because you have some places, whether they are daycare centers or people who service vulnerable populations, who really want to do that. They aren't subject to, the requirements legally, through the ETS or through a similar law. But what they are is they're concerned about their own private practices and making sure that their employees are safe and that the people they serve are safe. So there's that issue that it's bringing into fore, and we're certainly seeing it with contracts that we're currently negotiating. We're seeing a lot more things being put on the table about work-life balance and the ability for people to, gee, I want to work at home. I'd like to have more flex time. I'd like to have, an opportunity to work remotely, do telework, et cetera. So you're seeing a lot of those things that Ben is talking about, that shift, in the working environment, people having career ladders faster than they might otherwise. Why? Because I might not stay here for 10 years. Maybe I'm only going to stay for 5, and I'd like to have progression during that 5. That's possible. So it's really interesting how it is impacting even what we are seeing at the negotiating table.
Heather, anything to add?
I would add that one thing that I'm seeing, in addition to what's already been described, is more questions than ever before about religious exemptions, both for vaccine mandates and for even for mask mandates. And in terms of religious accommodations and religious exemptions, just generally speaking, for whatever reason, those don't tend to come up as regularly as other issues with respect to other kinds of protected classes, but they are most certainly coming up in this arena. And helping folks understand what really is a sincerely held religious belief that is really a tenet of a religion, as opposed to a personal belief, no matter how sincerely held. Helping employers work through what that really means has been something that I've been seeing quite a bit of, and the kinds of things that it's appropriate to ask an employee who is making such an assertion. Again, this is something that's coming up with respect to both vaccine mandates and even mask wearing.
Certainly, countless new frontiers has just in the last, couple years that have been opened up for all of us, and really appreciative of you folks taking the time to talk with us, talk with me, and provide this information to members to better understand, how to best serve their employees and just operate in a way that is, above and beyond compliance with the law. So thank you all for your time. I really greatly appreciate it. I know our members greatly appreciate it. And yeah, look forward to next time we all get together.
Thanks, Austin. Take care. Thanks, you guys.
Thanks, Austin. Good to see you, Karen and Heather.